did you come into contact with a nurse at the facility?
Yes, I did.
And if I told you who her name was Lisa Reynolds, I'm sorry. I'm sorry, I won't give that. But at that time, did you cop a feel of this person's buttock?
You're riding the circuit?
Right.
We have 2 cases, and they are 23 CR 22 and 23 CR 26, both styled the state of Texas versus Rebecca Foil. Am I pronouncing it correctly, like aluminum foil?
Yes.
But it's FOYIL. And in each of these cases, you're charged with aggravated kidnapping in 22 and aggravated robbery in 26. Both of these are first degree felonies. You have pleaded guilty earlier. Pre-sentence reports have been.
It's just on the aggravated robbery.
I believe one case is going to be dismissed.
That's
right?
correct.
The kidnapping. The aggravated robbery, 23 CR 26, you pleaded guilty to, and as part of this agreement, CR 22 will be dismissed. A pre-sentence report has been prepared. If the parties had an opportunity to review it, are there any corrections or changes to it?
Not from the defense, not from the state.
Then it's made a part of the record for all purposes. And the agreement here is whatever sentence shall not exceed a cap of 10 years in prison. So let's look at our options. No less than 5, no more than 10 years confinement if the court assesses flat prison time. You can be placed on deferred or unadjudicated probation up to 10 years. And I don't believe regular probation is an option in this case.
That's correct. That's correct.
All right. Go ahead. Defense, you may go forward.
No, this was an unfortunate set of circumstances.
For the victims.
I'm not going to try to minimize Ms. Foyle's participation in these offenses. She's pled guilty. Another court probably should review the pre-sentence report where she's adumbrates her purported involvement in the cases. I've explained to her, prior to her entry to the guilty plea, the law of parties based upon what the state has represented to me to be the facts. I believe that she would be exposed as or at least a party to the offense of the conviction. She understands that, and her guilty plea is predicated upon that theory of parties, as well as what the state might have been able to prove that controverts her version of the events. And speaking with her, I know that she's generally remorseful, or at least appears to be, to my estimation. She knew and I guess considered the victim to be a friend at one point, at least. And as part of the plea agreement, she stands ready to cooperate with the state and the prosecution of the remaining defendants, and up to and including testifying in court against them. And
what's the status of those?
That's true of whether the court gives her probation or not.
We have the other young lady in the case has pled guilty to the offense to the aggravated kidnapping, and the other 2 gentlemen that are charged are pending. Yes, being kind.
That term is used loosely. Yes, if I'm reading this correctly.
Yes, sir.
Individuals. But that's where it stands, Your Honor. I think she's in a position, I think, to.
When is it set for trial? Lacey?
It's not.
Those other 2 are not?
Oh, I'm sorry, Judge. I don't think about her cases. Who are the co-defendants?
Yours. Of course. Okay. These were the indictments came up in February of this year, right?
Yes, sir.
So it may just be said close to
end of the year.
How long have you been in jail? Since February?
16.
When the announcement.
October 2nd for Adams.
On the backside, there's another codependent man at the top.
October 23rd for Franklin.
That's it. The other lady's set for sentencing on August 31st, I think.
Is that Weatherall?
Yes, she's set for sentencing.
Yes, on the 31st.
Yeah.
Weatherall's the 31st. The two male defendants are set for trial in October.
And it shouldn't come as a surprise to the court to know that methamphetamine was involved with these cases as well. And the Stroil has struggled with and again, I'm not proffering this as an excuse, but I think that it frames sort of who she is or where she's at, substance abuse issues. And should the court, I think there's a substance abuse assessment should be in the PSI, that should be part of any probation regimen, drug testing, whatever programs the probation department sees fit to address. I know she said she's been in jail for 6 months. She's regained her sobriety. I think the lucidity in her thinking perhaps it's returned somewhat to where she can fully appreciate what she's looking at and where she wants to go with the rest of her life. She does have familial support. Two individuals present in the court on her behalf, such that I think that that would be some additional help with her being able to conform with the conditions of probation should the court assess her for adjudicated probation. And of course, with the first, this is a first degree 3G offense. She's facing some pretty severe consequences if she gets revoked. So I think she appreciates that as well.
We're gonna
advise her and conform to with probation.
Same.
Did you see the interested parties, the victim in this case, has asked that they spend time in prison, and I adjusted their roles by giving them a limited amount of exposure to prison time. But I still think with this gentleman losing vision in his left eye and still having problems with his body, I think that prison time is more appropriate than probation in this case.
You pleaded guilty to this, which is intentionally, knowingly, and recklessly causing bodily injury to another by kicking and hitting him about the head and body with hands and feet of the defendants, and a deadly weapon, namely steel toe boots, were used.
And again, I advise you to law parties.
I know. I want to know in the law parties to articulate what part you played in this other than watching, because that's not the way I read this probable cause affidavit. But I'm this far from sentencing you. I'd like you to, I want to hear it out of your mouth, but watching something happen is an inhumane thing to do, but that doesn't mean that you are culpable of a crime unless you had a duty to intervene. And that's what you're saying. All you did was watch something happen.
She said she disarmed.
I want her to speak, please. She didn't have to, but I'm about to sentence her.
I don't remember. I don't know. I can't say that I did.
And she's going to testify for the state?
I didn't
No,
She said she's available too, and I don't know
I
that I'm
don't think
calling
she
it.
has anything. She doesn't sound, she's not volunteering anything
She
at
saw,
all, except,
she saw the other individual assaulting.
so what? I mean, that's a terrible thing to stand by and do nothing while somebody is being beaten, but that's not what the probable cause statement says she did.
Do you have steel toe boots on?
I don't even own boots. Stephen Adams.
I'm not saying you had steel-toed boots on.
I think that was what was your sign.
It doesn't say she has steel-toed boots.
There were still
Somebody did, or two people did, but she still had an active role in this.
He has limited criminal history.
She also is expressing limited forthrightness.
I can't change the facts.
You can't speak. I'm asking her to speak, and you're doing the best you can. But
I never hit him. I disarmed him.
this could have been capital murder. What are you crying about? I feel sorry for the victim.
I do too.
Well, you were part of this.
No.
You didn't feel sorry for him at the time he was being stomped to death, almost to death, or waterboarded, which somebody going through that believes they are about to drown, which is, according to authorities, about the most desperate feeling you can go through as a human. But you're just going to sit there and weep and say you didn't do anything? Is that your final answer? That's how you're going to respond to this?
I did.
You did what? What'd you do?
I hit him.
Mm-hmm. What they said. That's what this says. What else?
I hit him.
Why would you do something like that to somebody who was defenseless? That's just mean. That's just mean.
I go back again to methamphetamine, and I don't proffer that as an excuse, but it does change people's perceptions and judgments and empathy.
I wish every day I could apologize to him. I really do.
Well, that makes it well.
No,
That undoes
it doesn't even.
you can undo the terrible act that he had to go through. Just when you read these reports, when people are involved with drugs, the reports that are made, everybody has a different story. Between I don't remember anything to everybody else was doing it, and it's like just a drunken stupor in people attempting to explain what they had just done. That's what happens. That's what I read all the time. And that's what drugs do. Hurt people. People are left to die. And then the folks are called upon the carpet to explain their actions, and everybody points to the next person. There's absolutely no sense of responsibility.
No, August 31st.
I mean, just a small tidbit of what the victim. As soon as he got to their apartment, they began to punch and kick him.
He had a room there, didn't he? Was he living there?
Yes, sir.
White advised he woke up to Franklin and Adams dragging him against his will back to an apartment, which was the kidnapping part. The victim stated they picked him up by his ankles and his wrists. As soon as he got into their apartment, they began to punch and kick him. This occurred in the living room. All four, Franklin, Adams, Foyle, Featherall, were kicking and punching him. His face was being stomped on. Foyle was kicking him as she was holding her little dog, because she actually dropped the dog on him while she was kicking him. You can't make this thing. Now the dog is a witness. Yeah,
Well, I don't think the dog was sick.
Your whole, yeah, she's taking care of the dog while you're helping beat someone almost to death. You can't play it both ways. You can't be an animal lover and then try to be a part of killing somebody. That's just terrible. That's schizophrenic in life kind of a thing. They were laughing at him while he was being beaten. Right, stay. What do you?
Asking for the 10 years, Judge.
All right.
I think due to her limited criminal history, but her part in it, I think that's fair.
Miss Foyle, what would you like to say, please?
Sorry. I really am. I really am, and I've been working on being a better person in the past few months. I would really appreciate a chance to prove that I can do this, a chance to be with my kids, and just apologize to Bob. I know I can't do it personally, but I'd like for him to know I'm sorry.
But two other things. I don't think she said any write-ups that she's in jail. Mr. Laird needs some other information. To my knowledge, I don't think she said any write-ups. And she's not eligible for shock probation. There's a 3 jail.
No.
I want to be better.
I have no. At the end of the day, I'm just going to summarize this. It doesn't matter what you want. It's the choices you actually make. Okay.
Working on making better choices.
How old are you now?
28.
Mm-hmm. In your criminal history, it says here, this 10 days in jail last year for hindering apprehension or prosecution
Yes, sir.
out of Scurry County.
Yes, sir.
I'm not familiar with that. 254 counties, and I thought I knew them all, but I didn't know Scurry County is in Texas.
Texas.
Where?
Texas. Abilene, close to that.
It's Scurry? Is the name of it? I never heard of that. I'll be darned. Thought I was familiar with all the names. Anyway, what was that all about?
I lied about my ex-boyfriend's name.
To the police?
Yes, sir.
So you got in trouble for being dishonest.
Yes, sir.
Okay. And then here, last year on May 21st, family assault. What was that about?
Got in a fight with my roommate. She's not here.
Who was your roommate? Who was your roommate?
Her name is Charlotte Wade.
Okay. So, now what did you say now? She said you hit her? What did you do?
We argued and I grabbed her by her arm.
That was it? Just grabbed her by the arm? Well, you pleaded guilty and was sentenced to 30 days in jail for that. For grabbing her by the arm.
It cost her pain a bit, though.
I know, but truly, grabbing people by the arm doesn't normally result in a criminal charge unless it's done in a way that's hostile. Right?
Yes, sir. I'm taking AA in jail and I plan on taking mental health. I'm taking AA in jail and I was.
Why?
Because I have the substance abuse issue.
You have
a substance abuse issue. I've already been looking into recovery and I'm planning on getting my mental health evaluated if I get the chance to get out of probation. I just want to try to be better.
Sorry. Move. That gets everyone's attention. See, the problem with all this, Ms. Boyle, is believing what you have to say. Misbelieving what you have to say. And the pre-sentence report that was introduced into evidence here, yeah, I've been waiting on you to resolve it. And during the pre-sentence interview, the defendant, you told the pre-sentence officer, the probation officer, you did not take part in harming the victim, nor did you have any plans to rob him of anything. You were in a back room getting high with another person, another female, and only knew what took place because your mother told you about it after hearing about it. That's what you told the probation officer. You lied then or you lied now. But the report shows more culpability than you told the probation officer, who is an officer of me.
Yes.
He or she, it was Candy Banks. She is a representative of this court.
Yes.
And so you lied to her, you lied to me. That's no way to resolve anything. But we have the reports and the investigation, and it showed you clearly took part. You may not have been the most culpable of them. The men looked like they were men. The males looked like they were the leaders of this group, but you certainly didn't help the victim, and you took part in harming. Yes. But it doesn't do, your cooperation and help does little when you say certain things here in this report to the probation office, which you had no reason to lie, but you did. And then if you were to cooperate and be called as a witness, the state would have to say to the jury, she's not, I know what she's saying here under oath, that's self-serving here in some degree, that she had little to do and that they had to do with this, but then she lies. So your effectiveness in doing something good out of this is evaporated. Which is what we learn. What terrible web we weave when we attempt to deceive. We learned that when we were little kids. This is terrible. This is a terrible thing. This is torture of another human being. Anything else? If not, I'm going to find, Ms. Foyle, you have pleaded guilty today voluntarily. You are mentally competent to do so. You understand the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony aggravated robbery. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. The judgment shall show an affirmative finding that a deadly weapon, mainly steel-toed boots, was used in the commission of this offense. This is terrible. And you could have been here with the court or a jury making two choices, either life without parole or the death penalty, because that was what almost happened. That would have been the only two choices. It's a shame. But after all of this happens, at the end of this, you put an exclamation point on it by name to the probation office. Which really takes this out of the court's hands of decisions. That negates a lot of the options I will consider. Because acceptance of responsibility never happened until just a few minutes ago. Which doesn't help you, and you become little help to the state in its prosecution if they were going to call you.
Yes.
Which is where your help and the wiggle room that the court could use in fashioning a sentence lighter, but you don't deserve a lighter sentence.
Yes.
You were responsible for this. And the other ones, I'm sure the state's going to ask for life on those. And these are disturbing sets of facts. So you could have done better if you'd have just made better choices along the way. Up and even after arrest, you should have made better choices. There's a dismissal on one of these. The bailiffs will be able to take care of that. Sarah Bramblett.